Hi everyone, welcome to the live virtual classes of Board of Studies ICAI. So we are on to our topic of interpretation of statutes under the paper corporate and other laws. And as we discussed in our previous session, this is towards the end of your lectures and this is the towards the end of the topics. We have already covered the General Clauses Act once, and we have talked about interpretation of statutes briefly. And if you remember our previous class, we have discussed about the objective of interpretation of statutes, the background, the uh, uses of interpretation, and what are the rules of interpretation. We were on that particular part, and primary rules we were discussing. And we will be discussing about the remaining secondary rules and then internal and external aids to interpretation. This is what we are trying to do today. But again, as a recap, I would like to take you back to the four basic, principles of interpretation which we discussed. Okay, and these are very important. Whichever interpretation you do, whichever law you are looking at or doing an interpretation of, you have to follow these four basic rules. The first rule of interpretation, or first principles of interpretation, is intention of the legislature has to be found out. So what ultimately the courts are doing is they are trying to find what was the intention of the legislature when they make that particular law, and the effect has to be given to that intention. Intention of the legislature is nothing but the intention of the people. Because if you see the constitution also, in constitution it is mentioned, we the people of India, having solemnly resolved. So basically the constitution is given by we the people, government is by the people, and the government makes the laws, which is actually the will of the people. And that is where all laws, whichever come for interpretation before the courts, it is important to find the intention of the legislature. How do you find the intention of the legislature? Intention of the legislature can be found by the words which are written in the statute, right? And that is where your third principle comes into picture, that if the meaning is plain, effect must be given to it irrespective of the consequences. So you are basically going to the literal rule. You read the law, whatever it is making a sense, you apply that particular law. You are not bothered about the consequences of that particular law. However, there may be situations where conflict arises, or there may be situations where confusion arises. These are the situations where the interpretational rules comes into picture. And we will talk about some of these tools and some of these rules, and it will be easier for you to understand that better. Another important principle is that you cannot, take out a particular provision and interpret that particular provision, dehorse the other provisions of the law. Dehorse means ignoring the other provisions of the law. So you have to basically read this whole statute as a whole. And very important thing is context is the king. So you have to also see that what is the context in which the law has come up? What is the necessity of that particular law to be there? And that objective, that understanding of that context is very important when you are making the interpretation. Like, for example, if you are talking about Motor Vehicles Act, you have to see what is the context in which the law has been made. Why law has been made? It has been made to take care of the licensing requirements of vehicles. It is there to take care of the motor vehicle accidents. This is the context with which the law is made. And when you are reading the provisions, you should be guided by that context. This is what is the second basic principle which it talks about. And ultimately, if you are trying to make the interpretation, you are trying to read the law, and you are trying to see whether the law is making sense or not. And at that point in time, if you find that the provisions which are there in the law are not working, or it is not giving the meaning you want, then in that situation, you are trying to make the law effective and workable by way of construction. Like, for example, I'll give you a simple example, that where there is a shall and you require that it should be may, then you read it as may. Where there is may, you want that it should be shall, you read it as shall. This is just to make the statute effective and workable. Like, for example, in the Human Rights Act, Constitution of the State Human Rights Commission is mentioned that the states may constitute a Human Rights Commission. So in one of the decisions, the Supreme Court said that this may has to be read as shall. It cannot be a situation that there is a Human Rights Act and it provides for Constitution of State Human Rights Commission, and Human Rights Commission is not constituted for years because it uses the word may. And hence the court interpreted this to be shall, so that human rights commissions can be there in the states. So this is just one example. So you have to constitute the statute to make it effective and workable. If you are clear with these four basic principles, interpretation rests on these principles. So multiple times in decisions, you will see this principle being applied. So say, for example, a particular case comes to the court of law. The court of law will have a look at that particular thing from the intention of the legislature. Let me take an example very closer to you people. Like, for example, under the Companies Act, you have a new authority called National Financial Reporting Authority, that is NFRA. You people, all of you must be aware about it, right? Now, that particular law has come up. And at the same time, we are having ICAI, which regulates the chartered accountants. Now, these are two different laws. And there was a litigation also which came before the Supreme Court about the authority of NFRA vis-a-vis the ICAI. And that particular decision, you see what court has gone. Court has first gone into the question, what is the intention of the legislature? Why this legislation came up? What was the objective of having this particular legislation? There was a requirement of an oversight mechanism, and there was a requirement of looking at any trouble or issues relating to the chartered accountant profession, or generally in the financial accounting profession. And then this particular authority was established. And if you see the objects and reasons, you will come to know about the intention of the legislature also. So this is something where you draw it. But what do? You have to read the law as it is, whichever it is mentioned there. So you go to the section concerned under the Companies Act and try to read what law has said. So if the plain meaning is plain, effect has to be given for that particular thing as plain. And you have to read the statute as a whole context. So NFRA features in Companies Act. So if you read that particular law, you will find out that there were a lot of corporate frauds happening. Even after having the corporate fraud provision in place, there was a lot of frauds happening, and there was a requirement to look into that particular fraud. And that is how this Serious Fraud Investigation Office was also incorporated. So this interpretational exercise, you will ask all these questions, that why this particular law came up, what was the law before, whether after coming up of the law things have changed, what is the remedy which is mentioned in the law. All these questions are asked by the court, and these basic principles becomes a very, very important tool in the hands of the judges to interpret it. Now the question arises, why you people are reading it? Because you have to also understand it from that context, because many a times you will see a provision where shall is written and you have to read may. There is somewhere may is written, you have to read shall. Then at that point in time, you should not get confused that why this is mentioned like this. At that point in time, you should be appreciating that aspect, and this is why these principles are important. Now let me move further, and this is what we were discussing in our previous class, and we suggest literal construction. So whatever is written, you go by the written words. You don't add anything, you don't remove anything. Okay, this is literal construction, and it is also referred to as the golden rule of construction. And this is the primary rule, and this is what is the principle also. If you will see, if the words are plain, the meaning has to be given similar. Then comes the rule of reasonable construction. So there are situations where you want to interpret the provision, and sometimes the written rule may not make sense. So you are trying to find out a reason behind that particular thing, and trying to give a functional approach to that interpretation. Okay, so it is not literal, but it is the functional approach which you are giving. Then comes rule of harmonious construction, and in the rule harmonious construction, basically there are two conflicting provisions in the law. Then you are trying to harmonize them, and I gave you an example from Constitution, that is directive principles of a state policy and the Constitution of India. These are the two different provisions. There you are trying to make a, make a harmony between the directive principles and fundamental rights. Though, if you will see under the Constitution, fundamental rights are having more weightage because it is enforceable. Directive principles are not enforceable, but still in a number of cases, court has held that directive principles have to be given weightage and there has to be a harmonious construction between these two parts, right? Now, in case of the Haydn's case, or you can say mischief rule, the interpretation exercise actually goes back to the historical perspective, or you can see the origin of the provision. So what it says, it basically says that whenever there is a law which you are trying to implement it, you try to figure out or find out that what was the law before, and when the law came up, what was the objective of bringing that law, whether it was to cure that mischief, and if it is so, then whether that mischief has been cured by it or what is the remedy available. Then this gives you a contextual understanding of the law and you are going to implement that particular law. Then there is a rule of beneficial construction, and as I told you that it is a kind of a tool of a construction. So in certain legislation where the law is made for the benefit of a particular class, community, or a particular religion or particular any dimension, then you have to see that the law is benefiting them. Like, for example, if there is something which is there for promotion of children, then you have to see the law from that angle. Like, for example, if there is a wages act, then you have to see that it is in the favor of the wage earners, right? So these are the rule for beneficial construction. Then there is something which is referred to as rule of exceptional construction, and this is basically to exclude or to differentiate the interpretation, right? A question has been asked that what is the distinction between interpretation and construction? So as you would see in all these situations, we are writing construction. Construction is an exercise where you are trying to deduce or construct something by way of an interpretation, right? So interpretation generally is that whatever is written, you are trying to interpret it, okay? You are trying to make a meaning of it. But construction is a situation where you are, trying to develop something or construct something. Like, for example, in case of rule of harmonious construction, you are trying to construct a relationship between two of the provisions in the statute, right? So these are the things which we have already discussed in our previous class. Today, we are going to cover rule of Ejusdem Generis, Doctrine Noscitur Sociis, and Doctrine of Contemporanea Expositio, as well as some of the other provisions also. We will talk about it in our class today. Okay. If there are any other questions, you can ask me right now. Otherwise, we will move further. Now, if we talk about this interpretation, there is one important interpretational exercise which happens because of conjunctive and disjunctive words. So there are two kinds of words. One is called conjunctive and the other one is called disjunctive. So when we say conjunctive word, it basically joins something. When we say disjunctive word, it basically separates something. And these words are and or. Okay. So many a times in the legislation, you will find that there is a term, there is a word used as and or, right? So and means you include them, or means you exclude them. So the word or normally is disjunctive and is normally conjunctive. However, by way of an interpretation, it is just like may and shall, but at times they are read as vice versa to give effect to the manifest intention of the legislature as disclosed from the context, right? So this is what was held in the case of Municipal Council versus Bishandas Nathumar. And you will see what happens is whenever there is an interpretation, and I'll give you an example for this, you will understand it better. So you have to see whether the and or is making a distinction or not. So in case of Professor Yashwal versus State of Chhattisgarh, The expression established or incorporated used in Section 2F of the University Grants Commission Act was read as established and incorporated. So it cannot be a situation that a university is established or incorporated. University has to be established and incorporated. So there has to be an incorporation having regard to the constitutional scheme, and in order to ensure that Act is able to achieve its objective and UGC is able to perform its duties and responsibilities, right? So you can see in the statute, it was mentioned established or incorporated. If they would have interpreted it literally as or, probably one of the words could only be applied, right? And then this could have given a different kind of a meaning. But here the courts interpreted that the legislature may have wanted it to be established and incorporated rather than or incorporated. Similarly, there is another case in Ishwar Singh Bindra's case where the expression substances in the definition of drug contained in 3B means something other than medicines. The word and used in the definition of drug in between medicines and substances is to be read disjunctively. So when you say and, here, ideally speaking, and is a conjunctive word, but in this case, it was held that the medicines and substances, you have to read it disjunctively, medicines or substances, because medicines and substances, because medicines is different and substances is different. So they wanted either medicines or substances. That is what was the idea here, which has to be read. So in Stroud's Judicial Dictionary, it is stated that and has generally a cumulative sense, requiring the fulfillment of all the conditions that it joins together. And herein it is antithesis of or. Sometimes, however, in such a connection, it is by force of a contents read as or. Similarly, in Maxwell on interpretation of statutes, it has been accepted that to carry out the intention of the legislature, it is occasionally found necessary to read the conjunctions or and one for the other. So you can see here it is the same situation as shall and may. And idea is basically to see the context. Then there is a term may, must, and shall. On this and or, I would also like to give you another example, and it is a beautiful example from the companies law. Okay, so you all must be aware that the companies can now be prosecuted for mens rea offenses, that is criminal offenses. If there is, say, for example, forgery case under the previous IPC 420, then whether the company can be prosecuted or not. The question came before the Supreme Court in Veliappa Textiles case. And in Veliappa Textiles case, the Supreme Court interpreted this particular term of punishment. So if you will see the punishment for 420, it says punishment with fine and jail term of so and so. So while interpreting this particular provision, the Supreme Court was of the view that how you can send a company in jail. So if you cannot send a company in jail, then there is this provision was not meant for company, and hence company were exonerated from mens rea offenses. However, things changed by way of an interpretation in Standard Chartered case, where the court interpreted this and to mean or. And it said, in appropriate cases, if it is an individual, even jail sentence will come up, but the company should not be completely exonerated just because the statute mentions and. It will be travesty of justice. That is what was held in Standard Chartered case. And they said that you read this as or, and whenever there is a company which is getting prosecuted, all the individuals who are associated with it will be going under the jail term, but company will also be fined. So this is how it happened, and this got further interpreted further in a detailed way in the Iridium versus Motorola case. So these are some of the examples where and or have been interchangeably used. I hope this concept is clear to you people. Okay. Now let me take you further on this dimension, that is may, must, and shall. And we have discussed about this in our General Clauses Act also. So there may be situations where you can use a shall in place of may and may in place of shall, right? So in Punjab National Bank versus Ghulam Dastagir's case, the statute stated that the landlord may apply to the court for eviction of the tenant in certain circumstances. Now, Supreme Court held that in this context may impose the duty, not a discretion. So if a landlord really wants to have the, eviction from the tenant, they shall apply to the court, right? Rather, may is not a situation on the landlord to apply eviction under the specified circumstances. May was interpreted as shall, as leaving it discretionary would defeat the statute's purpose of protecting landlords' rights, right? So this is one case where may was, held to be shall. In the state of UP versus Man Bodhan Lal Srivastav, this was a case in which section Article 323 of the Constitution stated it shall be the duty of the Union and State Public Service Commission to advise on disciplinary matters, right? Now, the question was whether consulting the PSC was mandatory or merely directory by the government. In this case, the court held that despite the use of the word shall, the provision was directory, not mandatory. Now, this can create confusion sometimes, but here it was said that the government is above that PSC, right? So if a PSC is constituted by the government, so in all cases, it is not necessary for the government to, take advice of Public Service Commission, UPSC. And hence, in that particular ground, they have said that it was a directory, not mandatory provision. This interpretation ensured administrative decisions were not invalidated solely due to non-compliance with the advisory requirement. So you will see similar kind of a situation in demonetization case we noticed. So in Vineet Narayan's case, where the consultation between RBI by the central government was considered to be a may matter rather than a shall matter. And it was said that, okay, fine, if there is a coordination between central government and RBI, it is not necessary that every time RBI should initiate the proposal. It may be a situation where central government comes up with the idea and it consults with RBI. So we should not go into the procedural details in that particular matter. Now, there was another case in, Lakshmi Narayan versus Union of India, in which the word use of word must in place of shall will itself be sufficient to hold the provision to be mandatory. So in some situation, you will see a word must may have been used in some statute. Generally, must is not a word which is used generally. It is the law uses only may and shall. The use of word shall with respect to one matter and use of word may with respect to another matter in the same section of a statute will normally lead to the conclusion that word shall imposes an obligation, whereas the word may confers a discretionary power. So if you find both these two terms in one section, then shall will say mandatory obligation, may say a discretionary power. But that by itself is not decisive, and the court may, having regard to the context and consequence, may. So this is something which you people are now aware about it, that it is all contextual, depends on the court, depends on the circumstances, depends upon the situation, the interpretation is taken into consideration. But here you have to also keep in mind that in normal circumstances, the court will go by the literal meaning. It will not read may as shall and shall as may. If it is doing that, then it has to give a reason for it. And in the order, you will find the reason as I gave you in 3 of the above cases. Now, there are certain terms, and we have already discussed this. These are called modal verbs. And you see the word shall is used to raise a presumption of something which is mandatory or imperative, whereas the word may is used. This slide you would recollect. We had also discussed this in General Clauses Act. Similarly, in interpretation, this is utilized many a times. Let us look at another case. This is, Dinesh Chandra Pandey versus Madhya Pradesh. Here to elucidate the words may and shall and interpret them, the Supreme Court held as under. And it said the courts have taken a view that where the expression shall has been used, it would not necessarily mean that it is mandatory. It will always depend upon the facts of a given case. The conjunctive reading or the reading together of the relevant provisions along with other provisions or rules, the purpose sought to be achieved and the object behind implementation of such a provision. This court in Sarla Goel versus Kishan took a view that word may shall be read as shall would be depending upon the intention of the legislature, and it is not to be taken that once the word may is used, it is per se would be directory. In other words, it is not merely the use of particular expression that would render a provision directory or mandatory. It would have to be interpreted in the light of the settled principles and while ensuring that intent of the rule is not frustrated. So you see, basically you are trying to go behind the intention of the legislature and find what exactly they are trying to mean. These are some of the examples which are given in your own booklet. So you can see here, in case of Section 3 of the Companies Act, a company may be formed for any lawful purposes by so and so. Now here used may shall be read as shall, because usage of word here says mandatory. So you cannot form a company other than lawful purposes. So you cannot have a company for unlawful purposes. So it has to be, may has to be read as shall. Similarly, in Section 21 of the Companies Act provides that documents, proceedings requiring authentication or contracts made by or on behalf of the company may be signed by a key managerial personnel or officers. Here, may is read as may. Okay, so it can be signed by key managerial personnel or officers of the company or duly authorized by the board on this behalf. So here you are reading whatever statute has said. Here you are not making it mandatory. Now, ordinarily, the word may is directory. The expression may admit confers discretion to admit. In contrast, the use of the word shall postulates a mandatory requirement. The use of the word shall raises a presumption that a provision is imperative. However, it is well settled that prima facie presumption about the provision being imperative may be rebutted by other considerations, such as the scope of the enactment, the consequences flowing from the construction. This is what the court has said in Vidarbha Industries Limited versus Axis Bank Limited. Let us look at it. This is a IBC case. And here the legislature in its wisdom used the word may. And we have seen this particular provision before also. So you will see under CIRP, the corporate debtor, if you see in respect of application for CIRP initiated by a financial creditor against a corporate debtor, but has used the expression shall in otherwise almost identical provision in Section 9, where initiation of CIRP is by operational creditor. So the fact that legislature used may in 7.5a of IBC, but a different word that is shall in otherwise almost identical provision of 9.5a shows that may and shall have two provisions are intended to convey a different meaning. It is apparent that legislature intended of the IBC to be mandatory and so section of to be discretionary. This is what held in Vidarbha Industries Power Limited case. So I think I gave you sufficient example of situations where may has been read as shall and shall has been read as may. Now, let us move to another rule, that is rule of Ejusdem Generis. But before I move to this particular rule, any questions on this particular point? I will be happy to answer. Any questions at this point in time? If you have, please ask. We are having less number of students today, but still, if you have any questions, I'll be happy to. Okay, it appears that you people are clear on this. Then let me proceed. And we are going to rule of Ejusdem Generis. Now, the rule of Ejusdem Generis, it seems there is a question. Yes, in context is the king, Anubhav, and you have to see that whichever interpretations I have given till now, I have told you about the context, why that has been interpreted like that. Like say, for example, this case of Veliappa Textiles and Standard Chartered. What I tried to tell you, that context. What is the context? Context there is that can the company be prosecuted for crimes? Now, what is the context? Context is that there are increasing number of corporate crimes. And if you just don't have a provision to prosecute a company for criminal offenses, then how do you deal with it? So, by way of an interpretation, they interpreted that the conjunctive word is disjunctive, disjunctive word is conjunctive. That is what has happened in that case. And that is how, even if in a statute there is a conjunctive word and in the punishment of fine and jail, court interpreted it as disjunctive and said that no, it is or, and in case of company, one will apply, in case of individual, both may, right? So this is what is about context in the case. I hope this clarifies your point. Now, let me, talk about this rule. This is an interesting rule, Ejusdem generis. So where specific words pertaining to a class or category or genus are followed by general words, the general words shall be construed as limited to the things of the same kind as those specified. I'm sure you must have solved this, general awareness questions where, or in, schools, you must have solved it. That is called odd man out, right? So you used to have 4, 5 things and you will find odd man out. Here, this rule applies when the statute contains an enumeration of specific words, right? Like say, for example, it is saying chair, table, or similar kind of a things. Then you have to read it from that context. Second, the subject of enumeration constitutes a class or category. So the subject must constitute a class or category. It should not be haphazard. Third, that class or category is not exhausted by the enumeration. So enumeration does not mention all categories. Then there is nothing left to be, applying the Ejusdem generis rule. Everything is mentioned in the law. So you don't have to read anything further. General terms follow the enumeration. There is a general term which follows the enumeration, and there is no indication of a different legislative intent. So again here, there is, if legislature mentions specifically that no, only in case of these 4 items, this law is applicable, you cannot include a 5th item. Okay. Now, for example, vehicles. If the law lists automobiles like trucks, tractors, and motorcycles, the general term vehicles would be interpreted to mean land-based transportation. You cannot include airplanes into it. Am I making sense to you? So this is what is the rule of Ejusdem generis. So if the list says that this law will be applicable to regulation of trucks, tractors, motorcycles, and other vehicles written there, then you cannot include here a steamer or a ship, right? So for ship, there will be a different thing. It will not include that. Similarly, in case of animals, if it lists dogs, cats, and other animals, the general term other animals would be interpreted to mean animals similar to dogs and cats, and it should not include birds or fish. Okay. So this is what is the rule of Ejusdem generis. I hope these 2 examples make it clear to you what is rule of Ejusdem generis. Now we will take some examples so that it becomes more clear to you. But I'll come to that in a while. Now there is another important secondary rule that is called Doctrine of Noscitur e Sociis. Okay. So Noscitur e Sociis has been the meaning. It says that the word is to be judged by the company it keeps. Okay. So if a word is in a company of another words, you have to draw the meaning from there. And that is where, again, context is the king. Okay. Now, Lord Macmillan said this. So associated words take their meaning from one another under the doctrine of Noscitur e Sociis. So say, for example, fresh orange juice is not a fruit juice. This is what was held while dealing with the Purchase Tax Act, which used the expression manufactured beverages, including fruit juices and bottled waters and syrups. This is the provision. Now, in this case, it was held that the description fruit juices as occurred therein should be construed in the context of preceding words, and that orange juice, unsweetened and freshly pressed, was not within the description. So it is basically, if you will see, preceding word is manufactured beverages. So fresh juice is not a manufactured beverages, including fruit juices and bottled waters and syrups. So this whole context will not be applying to fruit juices. So you can see in case of, probably this was a case in case of Purchase Tax Act. And generally these 2 rules, Ejusdem generis as well as this doctrine of Noscitur e Sociis, comes into play for interpretation in case of tax matters. You people must be aware, I think you have your subject of taxation. So the taxation of items depends on different classification. Okay. So different products may have different kind of a classification. Nowadays, you are having GST. So you see accommodation, which is an AC accommodation, has a different tax. Non-AC accommodation has a different tax. AC restaurant may charge taxes differently. Non-AC restaurants may tax differently. So all kinds of, I remember one of the articles which I wrote long back, and the question was whether bubblegum is a mithai, whether it will be a confectionery or, sweet meat shop in Haldiram or maybe any other shop. That sweet can be considered as similar to a bubblegum. So these are questions which will come up, and these rules help in interpreting these provisions, right? Let me talk about, there is another case, Pradeep Agarbatti, Ludhiana versus State of Punjab. And in this case, it was said, we are in no doubt whatever the word perfumery in the said entry number 16 draws color from the words cosmetics and toilet goods therein, and that so read, the word perfumery in said entry 16 can only refer to such articles of perfumery as are used as cosmetics and toilet goods are upon the person. The word perfumery in the context in which it has been used, therefore no application to dhoop and agarbatti. So you see what it is trying to say. It is trying to say that dhoop and agarbatti cannot be applied to a person, right? So perfumery here, the word is used along with cosmetics and toilet goods. So you cannot include agarbatti and dhoop into that particular definition or interpretation. So this is what is the rule of Noscitur A Society. Similarly, in another case, private dispensary of a doctor is not a commercial establishment. This is what was held in the case of Devendra M. Surti versus State of Gujarat. And here, the commercial establishment means an establishment which carries on any business, trade, or profession. This is what was said. The word profession was construed with the associated words businesses and trade. And it was held that a private dispensary of a doctor was not within that particular definition. So this is how you interpret different provisions, different laws, and that is how these rules comes into picture. I hope this example makes the things more clearer to you. Now, there is another doctrine that is called Doctrine of Contemporanea Expositio. Okay. So this doctrine is based on the concept that a statute or a document is to be interpreted by referring to the exposition it has received from contemporary authority. Okay. So it is based on a longer maxim that is called Contemporanea Expositio et est optima et forti senia in lege, means contemporaneous exposition is the best and strongest in the law. This means a law should be understood in the sense in which it was understood at the time when it was passed. So this is what it is trying to tell. So you have to go back to the days when the legislation was passed. You cannot just read it in the present context. This is what this law says. And the custom is the best interpreter of law. This is another maxim. Thus, the court was influenced in one of the cases that statute of NA by fact that it was that which has been generally considered as a true one for the 160 years. But remember that this maxim is to apply for construing ancient statutes, but not to acts that are comparatively modern. So whenever you are looking at the very, very older statutes, like I can give you an example. Previously, before the Bharatiya Nyaya Sanhita was there, we used to look at Indian Penal Code. So see, those particular law, when these were interpreted in the present modern context, the courts would go back and see what was the context at that point in time when the law was passed and try to apply those particular things in the present context. So it is important for you to go back and understand what was the law at that point in time. So this doctrine basically says that if you are applying an older law, you have to go back in time and see the context at that point in time and then try to apply that particular law in the present context. This is what was applicable in most of the cases, many of the legislations. Okay, like for example, Provincial Insolvency Act, or you talk about Official Secrets Act. These are all older laws. So you have to see, like so for example, law relating to sedition. These are the provisions which has to be read in their context of that particular time when the law was passed. This is doctrine of Contemporanea Expositio. Okay. Most of the times this doctrine is not very useful nowadays because now we all have modern legislation. So this doctrine or maxim does not apply to those situations. Now let us look at some of the other rules which are there. So one of the rules is legal fiction or deeming provision. So in the law, you have a lot of deeming provisions. I can give you one of the deeming provisions is he means she, right? So in the penal code, you will find that wherever the word he comes, it means she and third gender nowadays. So this is the definition. So there are deeming provisions. So if you see, affirmative and negative words are also there. So in Ramchandra Keshav Adke versus Govind Jyoti Chaware, the question was the statute in question imposed a specific restriction on alienation of land without permission. Okay. The provision used negative words like no transfer shall be valid unless approved by the collector. Okay. The court held that the use of negative language indicates a mandatory requirement, meaning transactions without approval were null and void. There sometimes you will find that the language used in the statute is affirmative. So what do you get the lesson from here? Wherever you find a negative word, that means that there is an emphasis, or it is emphatically mentioned. So it will be a mandatory provision. So any provision which is starting with no or notwithstanding or not in context with, if that is the situation, then you are going to have a look at them from a mandatory perspective. Then there is something which is called affirmative language. So the applications shall submit all documents by the stated deadline. Here, shall indicates an obligation. It could be treated as directory depending on legislative intent and context, but generally it is an affirmative language. Now see, for example, the tenant may install flooring, curtains or furniture made of wood. Here under the rule of last antecedent, made of wood would apply only to furniture, not flooring and curtains, unless the context suggests otherwise. Now see here, this rule is very important, right? So if there is a statement, the tenant may install flooring, curtains or furniture made of wood. Now if you want to read made of wood with all these three terms before, it will be impracticable, isn't it? You cannot have curtains of wood. Floorings of wood can be there, but somebody may insist that curtains of wood. Now, in any case, here the word may is written. So it is not necessary that it should be shall. But here rule of last antecedent says that made of wood would apply only to furniture, not flooring or curtains, unless the context suggests otherwise. So there is in law, you will always find this particular wording unless the context suggests otherwise. What do you mean by that? There may be a different situation in the law which has been mentioned specifically. If that is the situation, then you have to follow that situation. Otherwise, you go ahead with whatever is written. Now, this is where, some of the interpretation clauses are there. Now, if you read G.P. Singh, the law relating to interpretation, which he has authored, there are several other context and examples, and the court of law, particularly the constitutional court, keep interpreting these provisions and bringing some different dimensions to the interpretational exercise. And what lawyers have to do is every time search for new case law, find out that whether the case is supported by a different case law or not. Fortunately for you people, as chartered accountants, you don't have to go into that particular depth of interpretation. But generally, you should be aware that yes, this may happen or this is the context. So the bottom line is, as chartered accountants, when you are practicing or when you are studying, you have to be aware and vigilant about the latest interpretation on your area, whichever subject, whichever topic you are dealing with, particularly in relation to the taxation laws and corporate laws, the interpretational exercises. And nowadays, I think IBC is very important. So these legislations, you have to see the cases, often, and find out that what kind of an interpretation courts are doing on different subjects, different topics. I hope this, makes it clear. Now, before we move into the internal and external aids to interpretation, I would like to ask any questions you have till this point. I will be happy to answer any questions or any clarifications you have. Any questions, any clarifications, any doubt till this particular point? I hope I am audible to you people. Okay. So now, since you have understood till this particular point, now let us talk about the internal and external aids to Constitution. So when we talk about internal aids to interpretation, as the name suggests, internal aid to interpretation means you look inside the law itself to find out the meaning. What is one of the major principles? That you have to read the law as a whole. You cannot just be concerned about the sections or subsections. You have to read everything together. And this is what exactly the internal aids to interpretation or construction means. So any statute has multiple parts. So in a statute, you will find long title, preamble, heading, marginal notes, definitional sections, illustrations, proviso, explanations, schedules. So you have to read the statute as a whole. And all these items are referred to as internal aids to construction. Internal aids means internal help to interpreting or constructing a statute. So I hope you got this particular thing clear. Apart, when you are not able to interpret a provision by way of internal aids, then you have to move to the external aids. You have to find some more support outside the statute, and that is referred to as external aids or external aids to interpretation or construction. So what are the external aids? External aids could be the historical setting, like when the law was passed, what is the history of this legislation. And in many statutes, in many decisions, you would have seen that the courts have gone into the history of the legislation. The best example would be the insolvency decisions. If you see the insolvency decisions, their courts have gone into the T.K. Viswanathan committee report. They have gone into the previous winding up provisions under the Companies Act. They have said there what was the problems the law used to face. Generally, whenever you are applying the mischief rule, you go into the external aids many a times. Then external aids are consolidating statutes and previous law. So many a times, say for example, if you have to go for Companies Act 2013 interpretation, what would be an external aid? External aid would be Companies Act 1956. Though the law is repealed, but you can still go back to it for comparing the provisions. If there is an old case law, this is something which you will look at for external aids. Many a times, you also go to the usage. So statute may not have provided for something, but you want to see how society has been using this term. Like for example, in case of mercantile law, many a times people go to see the usage, how the trade used to happen, how the business people used to work upon this or trade upon this. Many a times you also go into the earlier and later acts and analogous acts. That is also one thing which you do in case of external aids. Right? Give me a second. Seems there is an internet failure. Am I audible? Are you able to hear me? If you can just confirm, one of you. Okay. Thank you, Anubhav. So if you see here, you can also go into the earlier and later acts and analogous acts. So you have to, you can go ahead in finding, I give you an example of company law. Similarly, under the IBC, you can go into the Companies Act and see what was the winding up provision before and after. Then another external aid is basically the definitions. So you can go into the dictionary to find out the definition of meanings. If it is not given in the statute itself or the General Clauses Act, you go back to the dictionary. Even reference to General Clauses Act is also an external aid. So you are not referring to the statute, you are going to the General Clauses Act. That is also an external aid. Many a times you will also go to the foreign decisions. So Indian decisions you can also refer, that is also an external aid, but you can also use the foreign decisions, and that will be a external aid as well. So these are the different provisions which have been there in external aids. I hope this thing is clear to you people. Okay. Now let me take you to another important element, and that is internal aids to construction. So now we will go into the depth of internal aids to construction one by one. Okay. Let us talk about the first one. And the first one, but before that, what is an aids to interpretation? This is something which I have already explained you, but just to repeat, assistance, support, or help. This is what aids. An aid is a device that helps or assists. For purpose of construction or interpretation, the court has to take recourse to various internal and external aids. Internal aids means those material which are available in a statute itself, though they may not be part of enactment. These internal aids include long title, preamble, heading, marginal notes, illustration, punctuations, proviso, schedule, transitory provisions, etc. When internal aids are not adequate, courts have to take recourse to external aids. External aids may be parliamentary material, historical background, reports of a committee or a commission, official statement, dictionary meaning, foreign decisions, etc. These are all external aids. This we have already told you now. When internal aids are not forthcoming, we can always have recourse to external aids to discover the object of the legislation. External aids are not ruled out. This is now a well-settled principle of modern statutory construction or interpretation. This is what O. Chinnappa Reddy Justice said in B. Prabhakar Rao's case in 1986. Now, it is also a cardinal principle of construction that external aids are brought in by widening the concept of the context as including not only the other enacting provisions of the same statute, but its preamble, the existing state of law, other statutes in pari materia. So what do you mean by statutes in pari materia? Statutes in pari materia means a similar kind of a statute and the mischief which the statute was intended to remedy. This is what court said in Supreme Court District Mining Officer versus Tata Iron and Steel Company case in 2001. So you can not only refer to your own statute, like say, for example, Companies Act, but you can also refer to a pari materia statute. Like say, for example, you people have to look at a statute of ICAI. There are two other professional institutions you people are aware, ICSI and ICWAI. So if something has to be interpreted with reference to ICAI, you can always refer to a decision or something which has been happened in case of ICSI that as a pari materia statute. Okay, I hope pari materia you understood by this. The legal principle of pari materia, that is Latin for one or the same subject, is used when interpreting statutes or laws that are related to each other in terms of subject, purpose, or objective. Like, for example, Competition Act and MRTP Act are pari materia, or you can say Consumer Protection Act and Competition Act that may be considered as pari materia with reference to consumer protection. The rule suggests that laws dealing with similar subjects should be interpreted harmoniously to achieve consistency. For example, IPC defines offenses while the CRPCs laid down the procedural rule for handling offenses. Since both statutes deal with criminal law, courts often interpret provisions from these codes harmoniously under the principle of pari materia. I hope this pari materia concept is clear to you. Let me give you another example. In KP Varghese versus Income Tax Officer, the Supreme Court has stated that interpretation of statutes being an exercise in the ascertainment of meaning, everything which is logically relevant should be admissible. Now I am coming to internal aids to constitution, and the first internal aid in a legislation is long title. So you see the example. This is the example of the Companies Act, and you are able to see the long title there. And what is the long title? There is a short title and there is a long title. So you see short title is the Companies Act 2013 is a short title, and long title here, what is that? An act to consolidate and amend the law relating to the companies, be it enacted on so and so place. So it is now settled that long title of an act is a part of the act and is admissible in the aid to construction. This was held in R versus State. So the title of a statute is an important part of the act and may be referred to for the purpose of ascertaining its general scope, and of throwing light on its construction, although it cannot override the clear meaning of the enactment. This is what was held in that particular case. Now, for example, here, if you see the Bharatiya Saksh Adhiniyam 2023 number so and so. Now here, what is the long title? An act to consolidate and provide for general rules and principles of evidence for fair trial. This is what is the long title. So you can see here, this is what is the long title. There is another law which was passed, Aparajita Women Child West Bengal Criminal Laws Amendment Bill. This has become an act now to amend the Bharatiya Nyaya Sanhita to provide for enhanced punishment and to constitute framework for expeditious investigation and trial of heinous act of violence against women and children. This is what is the long title. I hope you got it. Nothing much to worry in long title as an internal aid. So you can always include long title as an internal aid. This is another case, Ashwini Kumar Ghosh versus Aravinda Ghosh in 1952. This is the case arose in the context of interpretation of statutory provision relating to legal profession under the Advocates Act of 1926. So if you will see, a dispute emerged between two categories of legal practitioners at that point in time, that is advocates and attorneys. There used to be attorneys previously. Now after the Advocates Act 1965, everything is same, advocates. Previously there used to be munshis, attorneys. So the advocates who practiced in the high courts were enrolled under the act, and attorneys who were traditionally associated with the Supreme Court of Calcutta were referred to as attorneys. Now, the case required the Supreme Court to determine whether the terms of the Advocates Act 1926 permitted advocates to appear in all courts, including Calcutta High Court, or whether only attorneys were permitted in Calcutta High Court. So, whether the long title of Advocates Act can be used as an aid for statutory interpretation in resolving the question in hand was the question before the court. So what was the long title? Long title was an act to authorize advocates of the Supreme Court to practice as a right in any high court. Now you can see the long title itself is very clearly saying why this law has come up. This law came up because to give right to the advocates of the Supreme Court to practice as a right in any of the high courts. So attorneys could practice in other high courts also. So the court reasoned that the long title underscored the intention to harmonize and systematize the rights of the legal practitioner, aiming to eliminate unnecessary distinction between different class of practitioners. So this is what was held in this particular case. A good example of 1952. But nowadays, I don't think that long title they are referring. Statutes are very much clear. Recent examples you don't find in this long title thing. But this example gives you a clarity what we are trying to say. Then there is an interpretation on preamble. So all statutes will be having a preamble. So the preamble of a statute, like long title, is a part of the act and is an admissible aid to construction. So although not an enacting part, the preamble is expected to express the scope, object, and purpose of the act more comprehensively than the long title. The preamble to the act discloses the primary intention of the legislature, but can only be brought in as an aid to construction if the language of the statute is not clear. However, it can override the provisions of the enactment, right? So it can override the provisions of the enactment preamble. Now, see, the point is that let us take an example. You have the example of Constitution of India, right? So in Constitution, there is a preamble. Preamble is a guiding light for interpretation of the Constitution. We will come to that in a while. So if you will see this example here, use of word may in section 5 of Hindu Marriage Act provides that a marriage may be solemnized between two Hindus has been constituted to be mandatory in the sense that both parties to the marriage must be Hindus as defined in section 2 of the act. It was held that a marriage between a Christian male and a Hindu female solemnized under the Hindu Marriage Act was void. This result was reached also having regard to the preamble of the act, which basically said an act to amend and codify the law relating to marriage among Hindus. So it could not apply to Christians. For them, there was a special marriage act. This is also a long title interpretation probably. So you can see preamble plus long title. Now, let me take to another example. But before that, I think there is a question. Let me see. Okay, yes. And It cannot override the provisions. Yes, very true. It cannot override the provisions. Preamble cannot override the provisions. I said it can override the provisions, then my mistake. It cannot override the provisions. And it is written, it cannot override the provisions. Very true. Thank you. It appears that you all are awake. Thank you for that input. Now, coming to the Karnataka Contract Carriages Acquisition Act 1976 is to provide for the, acquisition of contract carriages and for matters incidental, ancillary or subservient thereto. This is the preamble. Now, preamble goes like this, and it says, whereas contract carriages and certain other categories of public service vehicles preamble, and I was discussing about the Karnataka Contract Carriages Act. There was a case which has been decided under this. I will just share my screen. Give me a second. Okay. So if you see here, the preamble was a longer preamble, and in the preamble also you can refer to the Constitution of India. Okay, Article 39 of the Constitution. That is something which is mentioned here. So the statement which you are referring here, the give effect to the policy of state towards securing state ownership and control of resources and community so distributed. This is Article 39 of the Constitution, Directive Principles of State Policy. So here the court went into the preamble and tried to understand what is the meaning of it. And it said, it is apparent from the preamble of the act that the primary object of the act is acquisition of contract carriages with a view to preventing misuse and also to provide better facilities for the transport passengers by road. So you can see here what was the objective of acquisition of private players into the contract carriages to make it public contract carriages. So this was something which was discussed. So preamble can be utilized as interpretation, and many a times they look at preamble for further interpretation. This is another one. Was a legislation which came up in West Bengal after the RG car rape case, and the West Bengal government came up with amendment to the Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita, providing for better provisions, or you can say stricter provisions for violation against violence against women and children. And in the preamble, you can see the scope of the law. It says specifically saying that it is to amend and in West Bengal to enhance the punishment or to constitute the framework for inter alia expeditious investigation and trial of heinous act of violence against women and children. So this was necessitated, and they thought that they have to make it. So whenever this law will be interpreted, you will see that the preamble will make a important element. And if you go back, you will see there was a Aparajita task force which was constituted, and the objective was to take care of this particular situation in case of a special, wherever there is an offense of similar kind of a situation there. This is a preamble to the Constitution, and you must have known that the preamble was also amended to include the term, secular and socialist into the Constitution during the time of the emergency. And at that particular time, presently also there is a lot of discussion going on around that. So the preamble is the part of the Constitution and enjoys a legal force. There is no question on that. The preamble is key to understanding the Constitution and interpreting its clauses. Preamble, together with fundamental rights and directive principles of state policy, are the most important part of the Indian Constitution. This was held in Keshavananda Bharti case, which is basically the basic structure doctrine case. Okay, so in 1973, this case it was held, and Supreme Court has many a times interpreted that preamble is part of the Constitution. Preamble, part of the Constitution, is a very important guiding light. And Supreme Court relied on the preamble in establishing that constitutional authorities draw their strength directly from the people of India, clarifying the character of India as a socialist republic, recognizing the possibility of nationalization of private industries in order to secure equality and justice, and granting the expression social justice the status of a constitutional right. These references are interpretive, yet their quantity and length indicate a more substantive role in Indian preamble in constitutional interpretation. This is what was held. This is what Ramesh C. Lahoti talked in his talk on preamble in 2004. Justice Lahoti was a very renowned figure. And you can see this is what the job of a preamble is, or preamble utilizes. Then you will see in statutes, we get an internal, it is heading. So you will find headings everywhere in the statute. So like, for example, here on the right side, I have shown, like in the chapter, there is a heading, incorporation of a company and matters incidental thereto. So if you see section 3 to 22 are dealing with incorporation. Then there is chapter 3, which talks about prospectus and allotment of securities. And then part 1 of it talks about public offer. So what is the relevance of these headings is the question. So the headings or titles prefixed to section or group of sections can be referred to in construing an act of the legislature. The head small, and generally you will see they will not define or they will not help in interpretation. Very, very exceptional circumstances. You can refer to heading as a tool for interpretation. Okay. But in any situation, this cannot curtail the meaning of the express provision. So, say, for example, if Section 5 on article says something, it cannot be constrained by just the word incorporation of company and matters incidental thereto, right? So, this is what is on heading, though an internal aid to construction, but not a very significant one. Now, let us move further. There are something which is referred to as marginal notes. So marginal notes are basically side notes and summaries, and they are found at the side of the section. If you see the provisions, you will find there. For example, in Bharatiya Sakshya Adhiniyam, I have given you the example. So you can see these are the side notes. If you are able to see, these are side notes. Facts bearing on question whether act was accidental or incidental, existence of course of business when relevant. These are all side notes. They are not part of the enactment, for they were not present when the act was passed in the parliament, but they have been inserted later. So hence they are not aid to construction. So these don't help. These are just for reference purposes, for reading purposes, but in interpretation, these will be not be utilized by the courts. Then there will be, and this there is a case also with reference to this, that in CIT versus Ahmed Bhai Umar Bhai, Patanjali Shastris declared marginal notes is in an Indian statute as in an act of parliament cannot be referred to for the purpose of construing the statute. And the same view has been taken in many other cases. Many cases show that reference to marginal notes may be permissible in exceptional cases. In certain cases, as I told you, that you may refer to it just like that, but marginal notes cannot be utilized. However, marginal notes in Constitution have been held to be part of the Constitution because that has been passed by the Constituent Assembly and therefore have been used in construing the articles. So as you see here, intention of the legislature is clear. If there is an intention of legislature in Constitution of India, they have mentioned it, then that can be utilized, but not in case of general acts. This is another example, Bharatiya Sakshya Adhiniyam. So you are able to see in this is mentioned in civil cases, character to prove conduct. These are all the marginal notes. Now, this is another interesting dimension which I wanted to present before you is with reference to a regulation. So all regulation don't provide these notes, but if you will see, there are certain legislative notes which are mentioned in this SEBI prohibition of insider trading regulations. And these notes are further explanation to the sections. This is one of the experiments which happened by SODI committee. So they provided for further interpretation so that there is no confusion. So you can see here in this section 3, it says this provision is intended to cast an obligation on all insiders, etc., etc. So you can see an additional explanation of the section is given. So this is basically a part of the provision. And if you see the justification for bringing this probably is not part of your syllabus, but since you are reading interpretation, I just wanted to give you an example of a unique kind of effort which has been put up in explaining the legislation. This is what one of them. So you can see here, no person shall procure from this provision is intended to impose a prohibition on unlawfully procuring possession of unpublished price sensitive information. So the rationale has been given. The committee which gave this recommendation said that in formulating regulatory policy, author of legislation should take courage not to stop short of articulating what legislation was meant to achieve, but intend to mean. Supreme Court of India has observed that authors of subordinate legislation ought to articulate what they intended to legislate when writing regulations. So this gives much needed clarification as to what was the objective of the legislation. Probably if such kind of an interpretation is there every time provided, then there is no need for further interpretation. You can read it. So these are the notes. Then in internal aids, you can also find definitional section or interpretation clauses. So they are very much part of the interpretation exercise. So the object of a definition or interpretation clause is to avoid the necessity of frequent repetition in the subject matter. And the purpose of definition is two things. One, to provide key and proper interpretation of the enactment. Second, to shorten the language of enacting part by avoiding repetition of the same words contained in the definition part every time. And the legislature wants to refer the expression contained in the definition. So whenever you want to construct definitions, you have to have a look at the restrictive and extensive definitions, ambiguous definitions, and definitions subject to contrary context. So restrictive and extensive, there are some definitions which are restrictive in nature and which are extensive in nature. So the legislature has power to define a word even artificial. Like for example, in section 8 of IPC, gender is defined and this is a pronoun he and its relatives are used for any person, whether male or female. So this is what has happened. In BNS, they have used the gender pronoun he and its derivatives of any other person, whether male, female or transgender. They have included transgender also in it. So he means she and transgender as well. So definition of a word in definition section may either be restrictive or its ordinary meaning, or maybe extensive or the same. So when a word is defined to mean such and such, the definition prima facie is restrictive and exhaustive. We must restrict the meaning of the word to that given in the definition section. We cannot include further things into it. But where the word is defined to include in such situation, the definition is prima facie extensive. Here, the word defined is not restricted to meaning assigned to it, but has an extensive meaning, which also includes the meaning assigned to it in the definition section. In situations where you find a word being defined as means and includes, in such situation, such as such, the definition is considered to be exhaustive. On the other hand, when the word is defined to apply to and include, the definition is understood as extensive. Let us look at some of the examples. So here you can see section 2, just a second, section 2M of the Consumer Protection Act contains an inclusive definition of person. And it has been held to include a company, although it is not specifically named therein. So the definition section may also be worded as is deemed to include. And in those situations, is inclusive or extensive will depend on such a word to bring a legal fiction, something within the word defined and which according to its ordinary meaning is not included in it. So the inclusive definition of district judge in Article 236A of the Constitution has been very widely constituted to include hierarchy of specialized civil courts, labor courts, industrial courts, etc. So this is a what you can say, inclusive definition which has been there. If you would recollect, I gave you an example about in the SARFAESI Act, the DM having the power, the Chief Metropolitan Magistrate having the power to initiate the proceedings under SARFAESI. And this used to include even the deputy DMs and deputy ADMs, etc. And including the advocate also. Advocate has not been held as contrary to the statute. So like that, you have to have a look at it. Article 236 in the Constitution of India specifically talks about interpretation. And you can see in this chapter, the expression district judge includes so and so, so and so, so and so. Judicial services means so and so. So you can see here. So wherever if it is includes, that means it includes many things. If it means means, then service consisting exclusively of person intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. So this is how you go ahead with looking at definitions. There are some ambiguous definitions. So it is normally presumed that legislature will specifically precise and careful in choice of language in a definition. However, many a times it becomes ambiguous. Like, for example, under the Industrial Disputes Act, retrenchment means the termination by the employer of the service of a workman for any reason whatsoever. Now, otherwise than as a punishment inflicted by way of disciplinary action, but does not include so and so. Now, this is a case where termination of the service of workman as a result of non-renewal of contract of employment between the employer and the workman concerned and its expiry, or of such contract being terminated under the stipulation in that behalf contained therein. So similar, these kind of situations may arise where there is a question. Like here it says for any reason whatsoever. It can include anything, right? But since there is a further explanation given that these are the items, you cannot remove anybody or retrench anybody for whatsoever reason. Now, this example is there. Example number 12, you can see here, in the case of termination of service of a seasonal worker after the work was over, does not amount to retrenchment as per the Industrial Disputes Act, right? So this has been interpreted from 2BB. If you can see, termination of the service of workmen as a result of non-renewal of contract of employment, it is not a retrenchment as per the 2BB of the Industrial Disputes Act. But the termination of employment of a daily wager who is engaged in a project on completion of a project will amount to retrenchment if the worker had not been told when employment that his employment will end on completion of the project. So these are the two important cases which tells you about the ambiguous definitions. Now, definition, there you will find many a times definition subject to the contrary context. So when a word has been defined in that interpretation clause, prima facie, the definition governs whenever that word is used in the body of the statute. So this is an example. So this is a case of, in the case of Vanguard Fire Insurance Company Limited, you will find in this case, they have looked at the term word insurer. So what was the definition of insurer? They wanted to find out that what is the word of the insurer. And you can see quote here said, the word insurer has been used to indicate the company which is not actually carrying on the business of insurance, but is intending to do so and is applying for registration. So this is how you go ahead to look at the definition of interpretation of definition. Now, if you the words mean and would appear some goes on because of statutes. Yeah, so when we are reading this Soumya in General Clauses Act or interpretation, means and includes, they are same, none the same, nothing different than that. The only thing which you need to remember is, if in your question it is specifically mentioned General Clauses Act, we are referring to that section. But if it is not mentioning to General Clauses Act, then we are referring to any kind of a legislation. So definition is not only given in General Clauses Act, but definition you also find in the statutes, all statutes. Let us take an example. In this case, it is Insurance Act. So here, when we are referring to means and includes, we are referring to Insurance Act. But say, for example, definition of insurance or definition of a particular word is not given in Insurance Act, where do you go? You will go back to the General Clauses Act and try to look at it. So this is what you should remember in mind. Generally, there will be no conflict between the principles of interpretation and General Clauses Act. So you need not worry about it. I don't think there will be any challenge in solving these two questions. They are similar kind of a situation. Now, let us move ahead and talk about illustrations. So in many of the statutes, you will find illustrations as well. Like, for example, Bharatiya Sakshi Adhiniyam, if you read it, there is enough number of illustrations given. So illustrations appended to a section form part of the statute, and although forming no part of the section, are of relevance and value to construction of the text of the section, and they should not be readily rejected as repugnant to the section. However, they cannot have the effect of modifying the language of this section, and they cannot either curtail or expand the ambit of the section. So they are supportive in nature. You will not change the meaning of the section by looking at the illustration. Illustration are only for examples. So you have to see from that particular angle, and they cannot amend or change the main provisions. This is another example of illustrations in Contract Act. As you can see here, communications when complete. So a proposer by letter to sell a house to B at a certain price. The communication of the proposal is complete when B receives the letter. This is what exactly is defined there, right? Another example of illustration you can see in case of Juma Masjid versus Kodi Minandru Devaya. The illustration appended to section 43 of the Transfer of Property Act, we have deferred consideration thereof to the last, as there have been a controversy as to how far it is admissible in constituting the section. So this is the section, this is the illustration in that particular Transfer of Property Act. And in this illustration, when A sold the field Z to C, he had only a spes suctionis, but he, having subsequently inherited it, became entitled to it. This would appear to conclude the question against the appellant, but it is argued that illustration is repugnant to the section and must be rejected. So since you can see here, in this case, since illustration was not in line with the section concerned, illustration was rejected. If the language of the section clearly excluded from its purview transfer in which the transferor had only such interest as is specified in so and so, would undoubtedly not be legitimate to use the illustration to enlarge it, but far from being restricted in its scope as contended. So you can see here that illustration will not form as a support for interpreting or running down the express provision in the law. There is another case in which the reference was drawn from the above case in Mahmood's Shedol Afrin versus Yo. Now, here you can see it is the duty, the court said that it is the duty of the court of law to accept if that can be done, the illustrations given as being both of relevance and value in the construction of the text. The illustrations should in no case be rejected because they do not square with ideas possibly derived from and other system of jurisprudence as law with which they are, which the section deals. And it would require a very special case to warrant their rejection on the ground of their assumed repugnancy. So you can see what it is trying to say is that there has to be a harmonious interpretation. So if the language of the section clearly excludes from its purview certain matters, it would not be legitimate to use the illustration to the section to enlarge it. This is what was held. It is not to be readily assumed that the illustration to a section is repugnant to it and rejected. So you have to see a balance, right? So you cannot just reject the illustration. At the same time, you cannot change the meaning of the section by utilizing the illustration. It will go hand in hand. Then there is something which is called proviso. So in the laws, you will find a lot of provisos. Provisos are basically the exceptions. And you can see here in case of example, oral evidence in Bharatiya Sakshi Adhiniyam, you can see there are two provisos, right? One is provided that, the another one is provided further, right? These are provisos. So normal function of proviso is to accept something out of the enactments or to qualify something stated in the enactment, which would be within its purview if the proviso were not there. Now, usually a proviso is embedded in the main body of the section and becomes so, the integral part of it. Provisos that are so included begins with the word provided that. And effect of the proviso is to qualify the preceding enactment. So here in this situation, you can see oral evidence shall be so and so. There is an exception to this by way of a proviso. Okay. However, as a general rule, proviso is added to an enactment to qualify or create an exception to what is in the enactment. Ordinarily, a proviso is not interpreted as stating a general rule. Now, exception clauses are intended to restrain the enacting clause to a particular cases. Saving clauses is used to preserve from destruction certain rights, remedies, or privileges already existing. So there is a distinction between proviso, exception, and saving clause. So it is a cardinal rule of interpretation that proviso or exception to a particular provision of a statute only embraces the field which is covered by the main provisions. It carves out an exception to the main provisions to which it has been enacted as a proviso and to no other. So proviso is applicable only with reference to a section in which it is referred to, not generally to the act. So exception is intended to restrain the enacting clause to a particular cases. Proviso is used to remove special cases from general enactment, and saving clause is used to preserve from destruction certain rights, remedies, or privileges. Now, this is a further distinction between proviso, exception, and saving clause. So as you can see in this particular chart, purpose of proviso is to limit or qualify the main provisions, whereas in exceptions, it removes a particular case from a main provision, and saving clause preserves rights or effects of a repealed law, right? Scope, in case of proviso, it operates within the general rule. In case of exception, it excludes a case entirely from general rule, and saving clause protects certain situation from the change which has been made by the law. And effect is it creates a condition or limitation. It is makes the excluded case inapplicable. And here in saving clause, it ensures legal continuity. These are some of the examples of that. I will give you this particular slide. So please have a look at these examples because I have to cover the other clauses also. So I think this is fine with you. Then there is something which is called explanation. So in law, you will also find explanation. So explanation will be like this. You can see I'm giving you an example of Bharatiya Sakshi Adhiniyam. So here an explanation is at times appended to a section to explain the meaning of certain words or phrases used in the section or of the purport of that section. An explanation may be added to include something within the section or to exclude something from it. So generally you will find this exception like in one of the cases of Sundaram Pillai versus Pati Bia Raman. Fazal Ali gathered the following points to explain what this explanation is, right? So explain the meaning of intendment of the act itself, clarify any obscurity. These are the reasons by which explanation has been provided. However, these explanations cannot be the statutory law. They are there only to explain the things, not to take away things. Okay, that is now. Yes, Soumya, I think I have answered this question to you already, that there is no need for, okay, there is a different question. Example 12 in ambiguous definition didn't understood. Once can you please explain? Okay, fine, I'll explain you. Example 12. Let me complete this, then I'll explain you towards the end. Now here you can see, fill up the gap. These are the reasons by which the explanation can be utilized. However, remember that explanation cannot override the sections. This is schedule. So in a law, you will find schedules as well. And in schedules, you see, this is an example from Companies Act. So these are schedules. And schedules form part of an act. Therefore, they must be read together with the act for all purposes of construction. However, the expressions in the schedule cannot control or prevail over the expression in the enactment. If there appears to be any inconsistency between the schedule and the enactment, always the enactment will prevail. Like say, for example, the schedule 1 refers to section 4 and 5. So they say schedule 1 cannot change the content of section 4 and 5. Section 4 and 5 always overrides schedule 1, right? So you have to read this schedule along with section 4 and 5. Now, there are interpretations. You have to also see, this is an additional material. Punctuation is not included in your syllabus, but many a times punctuation also serves a very important thing. Punctuation is important, and many a times punctuation can make or break the situation. So in many of the cases, punctuation has been interpreted, and punctuation becomes a very, very important element for interpretation. There are situations where in a contract, particularly interpretation of a contract, punctuations have led to losses of crores of rupees, right? So please be clear particularly when you are interpreting or reading out or writing a document or a deed, the punctuations should be very clearly looked at. Now, there is, I think there was a question on example 12. Let me take you there first, and then we will talk about. Yes. So this example 12 in ambiguous definition, if you look at it, there are two case laws which are mentioned here, right? And it is trying to tell you that termination of service of a seasonal worker after the work was over does not amount to retrenchment as per Industrial Disputes Act. I have given you the section Industrial Disputes Act above. So if you see BB, it talks about termination of a service of workmen as a result of non-renewal of contract. And this is under the exception of termination of retrenchment, right? So it is not a retrenchment, it is a termination. And in the other one, but the termination arrangement, this is what this case law says. So what is the requirement? The requirement of law is that when you are employing a daily wage worker, he should be informed that this is a daily wage work and your termination of employment can happen anytime or at this particular point in time. And if then the termination happens, then that termination will not refer to as retrenchment. This is an exception. Okay. I hope this is clear to you. Then let me move ahead and talk about punctuations I have talked. Yes. So this is there part of your syllabus. Statute must be read as a whole in its context. This I've explained you many times. Again, I will explain you. If you see example, let us read the example in your booklet. If one section of an act requires notice should be given, then a verbal notice would generally be sufficient. But if another section provides that notice should be served on the person or left with him or in particular manner or place, then it would be obviously indicate that a written notice was intended. So you have to read from a contextual situation. You cannot say that, okay, fine, I have given an oral notice and that is sufficient. So it is the elementary principle that construction of a statute is to be made of all its parts taken together and not of one part only. The deed must be read as a whole in order to ascertain the true meaning of its several clauses, and the words of each clause should be so interpreted as to bring them into harmony with another provisions, or if that interpretation does not no violence to the meaning of what the natural meaning of the thing is. Okay, so this is the context of a statute must be read as a whole. I hope this is clear because many times I have explained you this. Now we will move ahead with external aids to interpretation or construction. So when internal aids are not adequate, the courts will make recourse to the external aids. And the external aids are very useful tools for interpretation of construction of statutes as opposed to internal aids. But nowadays, the judgments are fashionable. You can see it starts with external aids without referring to internal aids, because the judgments, particularly of the Supreme Court, wants to give a background. And while giving the background, they look at the historical setting and all those particular things. Even if not necessary, they are mentioning it. Okay. So this is something which, has become a trend now. But if you see the older decisions, generally they would not do that kind of a thing. But particularly with reference to new legislations, like, for example, Insolvency and Bankruptcy Code, Competition Act, when the first decision came up, all these first decisions of new statutes, they do a historical, setting. They go back to the external aids, just to, formulate an argument, or you can say just to give a background or a flavor to the judgment, or you can say completeness to the judgment. They are referring to external aids, but not for the purpose of interpretation. But in certain situations, external aids like historical setting, usage, all these things are utilized for actually interpreting the provisions also. So let us look at one by one each of them. So historical settings is basically external circumstances where you are trying to see that how this particular law has come up, how historical perspective has gone to. So that is something which you look at it. So we have to consider whether statute in question was intended to alter the law or leave it where it stood before. This is historical setting. I gave you an example. Insolvency and Bankruptcy Court decisions initially refer to a lot of historical settings. How SRPC came up, DRT came up, all those things were mentioned in the decisions. Then, in case of consolidating statutes and previous laws, you refer to the previous several statutes, right? Like, for example, Companies Act in India, you refer to provisions under the 1956 Act. Section 212 of the 2013 Act regarding SFIO incorporates elements of the previous scattered law across different old laws, and it tries to draw that parallels and distinctions of that particular law. Similarly, you can see in General Clauses Act is frequently referred to for interpreting the terms in statutes that succeed earlier laws. For instance, if the statute does not explicitly define a term, court looks at how the term was defined and applied in previous legislation to ascertain the meaning of that particular legislation. Like, for example, in case of Arbitration and Conciliation Act 1996, the court used to go back to 1940 law to find out. Example of Competition Act. So in Competition Act 2003, the philosophy of the law which was there in MRTP got completely changed in Competition Act. So there was no need for a reference to MRTP Act. So competition law decisions no more refer to the MRTP Act decisions because the philosophy between these two decisions were completely different. Usage. Usage is also sometimes taken into consideration in construing the act. So the act done under a statute provide quite often the key to the statute itself. It is well known that where the meaning of the language in a statute is doubtful, usage, how that language has been interpreted and acted upon for a long period of time, may determine its true meaning. So the courts may look at the usage of that particular word in different decisions. And it has happened many times. The courts will refer to decisions to find out what does that word mean. But again, you have to see that the meaning of that particular interpretation is in context. So you cannot utilize a meaning of a term in one context into another context. And that is the reason whenever the lawyers quote a case, they have to also look at the facts of the case. So you cannot utilize the intention or try to understand what is the meaning of the intention from a rape case to a theft case to a murder case. These are three different types of cases. So whenever you are referring to the term intention in a rape case, will be different than a murder case or that. Similarly, in case of civil matters, if you look at it, you have to see it from that angle. Now, if we look at this term in Income Tax Act, there is an example. So in Income Tax Act, if you see, there is it includes several terms, which, like, for example, income, capital asset. So in CIT versus Taj Mahal Hotel, the Supreme Court of India dealt with the interpretation of the term plant under the Income Tax Act. And the question arose that whether furniture and fitting in a hotel qualify as plant. So the court relied on the usage in the hospitality industry, where furniture and fittings were recognized as integral to the operation of the hotel. Based on this understanding, the court held that such items fell within the meaning of plant. See, quite interesting, right? So when you go to a hotel, whatever fixtures are there, beds and everything is considered as a plant and machinery for the hotel industry. So this is how the taxation people interpret and then try to deal with this situation. Interesting one. Huh? Now, let us look at the earlier and later act and analogous act. So the general principle is that where there is a different statutes in pari materia, that is analogous cases are there, though made at different times or even expired, not referring to each other, they shall be taken and constituted together as one system and explanatory to each other. So this I have already given you an example. So you can see, for example, Companies Act 2013 and 1956. This is they will be considered as analogous. So where a single section of one Act A is incorporated into another statute, say B, it must be read in the sense which it bore in the original Act from which it is taken. Consequently, it would be legitimate to refer to all the rest of the Act A to ascertain what that section means, though one section alone is incorporated in new Act. Right? So this is about. So this is an example. Earlier Act, explained by the later Act. So not only may the later Act be construed in the light of the earlier Act, but the later Act sometimes furnishes a legislative interpretation of the earlier one, if it is pari materia, and if, but only if, the provisions of the earlier Act are ambiguous. Where the earlier statute contains a negative provision, but the later one merely omits that negative provision, this cannot by itself have the result of substantive affirmation. In such a situation, it would be necessary to see how the law would have understood without the original provisions and in terms of, repealed sections are reenacted. So here you just try to see that the provisions which are there in the earlier Act may be incorporated in the new law or may not be incorporated in the new law. But the provisions under the old law will not always change situations in the new law. But in exceptional circumstances where you are having a confusion to understand what the new law is saying, you can go back to the practice or go back to the situations which are there in the earlier law to understand that. And that is permitted, and that is sometimes it is also referred to as pari materia. So many a times you can also refer to the repealed Act. So where a part of an Act has been repealed, it loses its operative force. But still, from an interpretational perspective, you can go back to the cases and all those things to see what has been said in the history of that particular new Act. So this is how the interpretation is done of older Acts. Another important, resource or aid for external construction is dictionaries. So first we have to refer to the Act in question to find out if any particular word or expression is defined in it. Where we find that word is not defined in the Act, then we may refer dictionaries to find out the general sense. So the three-tier structure is there. First, you look at the definition which is mentioned in the Act. Then if there may be also cognate acts referred to. Like say, for example, if you go to the Competition Act, it says it provides definition clause and then it refers to definition in the Companies Act. So if you don't find a definition in Competition Act, you go back to the Companies Act. If you don't find in the Companies Act, where do you go? You go to the General Clauses Act. If you don't find anywhere any definitions, then you go to the legal dictionaries. And in the dictionaries, you will get that particular meaning. So, however, in selecting one of the several meanings of a word, we must always take into consideration the context in which it is used in the Act. It is fundamental rule that meanings of words and expression used in an Act must take their color from the context in which they appear. Further, judicial decisions laying down the meaning of the words in construing statutes in pari materia will have greater weight and than the meaning furnished by the dictionaries. However, for technical terms, reference may be made to the technical dictionaries. So many a times courts have referred to dictionaries to find out the meaning of the terms like debt, the creditor. These are the terms, and many decisions you will refer to reference to the dictionary, particularly Black's Law Dictionary. This is external aid. The last external aid which is mentioned in your booklet is use of foreign decisions. So in many cases, courts will also refer to, particularly Indian courts are very open to taking reference to the foreign decisions. And it has done so in many cases. Like, for example, in Keshavananda Bharati case, they refer to the judgments of United States, United Kingdom, Australia to articulate the basic structure doctrine. Similarly, in case of Vishakha versus State of Rajasthan, they refer to the CEDAW, that is Convention on Elimination of All Forms of Discrimination Against Women. In many of the Article 21 cases, they have referred to the UNHRC or UN documents. So courts have been very open to look at the foreign precedents, and they do it while interpreting the provisions. However, you see, principles for using foreign decisions is that these are persuasive, these are not binding. So foreign decisions are treated as persuasive authority rather than binding precedents. And you have to also see that it must be context sensitivity. The court must assess whether the foreign decision is contextually appropriate to domestic legal frameworks or not. Like, I can give you an example of recent, SEBI judgment. So SEBI, you people must be knowing, it is a Turkish company whose permission or security clearance has been cancelled because of this issue, cross-border issue with Pakistan recently. And the Delhi High Court has now said that we will not go into this particular matter because it is a national security issue, and that has to be dealt with. So there may be situations where they will not refer to, but in generally the courts have been referring to the decisions of the foreign jurisdiction. No foreign decisions can be referred which is going contrary to our basic principles, public policy, morality. These things, then those decisions cannot be referred to by the court of law. Now, there are certain rules of interpretation, construction of deeds and documents. So whatever rules of construction we have read till now also applies to the construction of deeds and documents. So you have to see, when there is a law is passed, the law is for everyone. When there is a deed and a document may not be for everyone. It is a consensus ad idem as per contract law, and it is the law, or you can say a transaction between two parties, right? And accordingly, it has to be dealt with. So for interpreting the deeds and documents, there are certain basic principles, and the first and foremost point is which has to be borne in mind is that you have to see everything from a reasonable man standard, and you have to see from the context of a reasonable man who has taken care to inform himself of the surrounding circumstances of the deed or document and its scope and indentments, would understand by the words used in the deed or document. Secondly, the principle of construction in case of a document and a deed as of statute does not differ so much except some minor details. So a deed must be read as a whole in order to ascertain the true meaning of its several clauses, and the words of each clause should be so interpreted as to bring them in harmony with other provisions if that interpretation does no violence to the meaning of which they are naturally susceptible. So this is Lord Watson saying the principle or laying the principle of interpretation of deeds or documents. In all cases, effort shall be made to find out the reasonable and well-informed person would understand by the words used in the deed or document. The golden rule of construction is to ascertain the intention of the parties to the instrument after considering all the words in their ordinary and natural sense. You don't have to do a super interpretation in case of deeds and documents. To ascertain this intention, the court has to consider the relevant portion of the document as a whole, and also to take into consideration the circumstances under which the particular words were used. Very often, the status and the training of the parties using the words have to be taken into consideration. Now, you people must be knowing that nowadays deeds and documents are drawn. You use lawyers to frame that particular document because if you don't frame it properly, then subsequently it may be subject to litigation and then losses. So if this portion, rule of interpretation and construction of deeds and documents, would have been so easy, probably we would not be having so many disputes in the court of law, because there is a conflict or there is a intentional dispute, I don't know. But most of the times the dispute relating to contract emerges because there is a difference of opinion in constructing the deeds and documents. So it is always better to negotiate these clauses one by one between the parties before, so that if any future dispute arises, it is not in relation to the meaning of the words in a deed and statute, rather than it is about the enforcement of those particular words or breach of that particular agreement, rather than interpretation of that particular term. Now, you should also bear in mind that the many words are used in more than one sense, and sense may differ, and accordingly you have to be very, very clear when you are entering into an agreement that what kind of a word you are using and what is its actual meaning. And most of the times, many times you will see in bigger agreements, they are mentioning the meaning of those particular terms also, specifically in the beginning of the conveyance. So in case of Nirmala Bala Ghosh versus Balai Chand Ghosh, it was said it is inexpedient to construe the terms of one deed by reference to the terms of another. So it is an elementary rule of construction that the same words cannot have two meanings, different meanings in the same document, unless the context compels the adoption of such a course. The document must be read as a whole, and the intention deduced therefrom as to what the actual term of the parties intend to agree. It may also happen that a conflict between two or more clauses of the same document may be there. An effort must be made to resolve the conflict by interpreting the clauses so that all the clauses are given effective. Here also, I will like to bring in the doctrine of severability. So you will see many a times in contract, if, say, for example, one clause is creating a conflict, so the whole contract doesn't go waste, right? So you have a severability clause in the contract, and you try to just sever that particular portion and then implement the rest of the contract. This also is possible in case of deeds and construction of deeds. So this is what is this paragraph telling. So this completes my session lecture on the interpretation of statutes. These are some of the books which you can think about reading in case you are interested in reading more on statutory interpretation. A very interesting subject. I am reading statutory interpretation since last 20 years. But every time I read it, I get fascinated because there is something new which court has decided, and it is very, very interesting. It is just like kind of a interesting novel where you find something new which is coming up every time. So this is an ever-evolving field. But I have tried to give you the basic principles as per your course material. And interpretation of a statute is nothing more than a simple logic. So if you are applying it with a common sense, interpretation is easier. And I don't think any of the questions will be difficult for you to solve in these general clauses and interpretation of statutes if you are having a basic general understanding of the laws and how it is going to be interpreted. So with these words, I would like to thank you, everyone. And now I'm open to questions. We can take a few questions. Yeah, you can put the questions on the chat box. There is a question from Miss P. Sir, enactment, section, and provisions have same meaning. See, when we say enactment, it is act we are referring to. And within the act, there is a section. And then there is when we say provision, provision refers to everything. It includes sections, subsections, clauses. These are all reference to provisions. What you need to differentiate or try to understand is between the act, rules, and regulations. So there is a difference between act, rules, and regulations. Act is always made by the parliament. When we say rules, rules are made by the government, either generally the ministries, respective ministries make the rules, and regulations are made by the statutory bodies, or you can say regulators. Like, for example, in your case, regulations will be made by ICAI. Rules relating to the ICAI will be made by Ministry of Corporate Affairs, and Act is always made by the Parliament. This is how it works. Any further questions? So I'll just stop sharing this. Yeah. Okay. Anything further? Okay. So can you please? Okay. What is that? Generalia specialibus non-derogant. Okay. So when the this particular term, this is a maxim, generalia specialis non-derogant. That means that whenever there is a special law, the general law will give way to the special law. So this is what this maxim means. So if you have a special law on consumer protection law or Consumer Protection Act, then Consumer Protection Act will have precedence over any general law. So say, for example, there is a definition in Consumer Protection Act. So you cannot refer to the General Clauses Act definition when you have a specific definition under the Consumer Protection Act when you are interpreting consumer protection law. You can only go to the general law when special law does not mention it. So this is what this maxim means clearly. So special law always have precedence over the general law. Like, for example, right now, if you see Insolvency Bankruptcy Code will have a precedence over the Companies Act as far as the corporate insolvency is concerned.
Good evening, sir.
Hi, ma'am. How are you?
I'm good, sir. So how's the class going, sir?
Yeah, it's fine. I think we have less number of students, but they're very interesting and they are asking questions. So this is actually a very core subject. So for lawyers and for them, it may be a bit heavy. I can understand that.
So are all the queries done, sir?
I'm just waiting on you only. So Anubhav is saying heavy, sir. This heaviness will go away once you start reading it. I will tell you, law is common sense. It is not at all heavy, and it is tried to be now. See, if it becomes too light, then nobody will ask you questions, Anubhav. So as a CA, as a lawyer, till the time it is a bit heavy, you people are needed. Otherwise, they will say that, okay, we are ready to do whatever is. A common man will be able to do everything. On a lighter note, I am saying this.
So Anubhav, I will add one thing to it. Someone of you asked about that Generalia specialibus non-derogant. Why it seems heavy to you? Because it's a Latin maxim. But if I break it down for you somehow, like, just understand it is not possible for a teacher to cover everything in a class. But as students, what we can do is we have the power of our phone and we can start searching that why is it. If you have that burning desire within you, then it will become easy. Like for this, I will say, I think it is a Generalia specialibus non-derogant. Okay. Why they are using the word Generalia? Because it means something which is journal. So here it means general laws. Okay. Specialibus. So something specific or special law. And non-derogant. We always, it's just something in negative. So non, not. A derogant, which is like overriding. So which is not overriding. So if we read it as a whole, so Generalia specialibus non-derogant. So journal law will prevail or not prevail. Do not prevail over specific law. Though you have to learn that line. There is no way out of that. But if you break it down, it will become very easy for you. And now it will come to your mind that you can easily use it for, why you are using it for harmonious construction. We say harmonious construction, two things joined together. So that's why Generalia, journal things will not prevail over specific law. Sir has given a very good example of it. But if I talk about it in journal, like layman terms, if there is an example like all public holidays are non-working days. But if the Banking Act says that the Baisakhi is a working day for for the banking people, so for them that law will prevail. So we have to take things. अगर हम इसको difficult सोचेंगे ना, see, in every attempt, an 8 marks question, 8 marks come out of this chapter. So at least 2 questions come, and if they ask it more, like it will be either 8 or it will be 6 or 12 kind of a thing. Just understand, once you change your mindset about this, it's about everything. You will find it much more easy. Okay. So, can I ask, I wish they had written this in English only. Do we have to write in these Latin words? Okay. A very good question. I would add to it. They could have written it as simple as it कि अरे यार general law को छोड़ो ना सीधा specific law पढ़ो. I think you can understand Hindi also. So why they are making it difficult? Had things been so easy, what was the need for a chartered accountant or a lawyer or advocate? Or rather, if things would have been so easy, our job would have been like, I would not have been here. Sir would not have been here.
So that is on a lighter side. I agree to this, but if you see the historical, like these students should understand why it is like that, because our laws are coming from, if you see the origin of laws, comes from the Greece and Latin places. Okay, so it was European system which actually made these particular laws. So from there, these maxims and everything has started. And when Britishers came and our laws came up, so these laws got incorporated into the whole system. And maxims has a purpose, basically. Maxims actually contains a lot of legal principles. Like say, for example, right now, 2 of us are teaching you only 4 words maxim. 4 words maxim contains so many legal principles, so many of wisdom into it, right? So that is the purpose of a maxim. In short, if you would recollect, in our olden days also, our elders used to use very, very short phrases, to convey things. Now, objective is this, muhavre, or you can say, fakra, hamare yahan pe fakra bolte hain. So
idioms.
Yes, idioms. So those are basically meant for explaining the things in a shorter way. So message is conveyed certainly. So that was the objective. And for you people, it becomes easier now to understand it in that language. And since it has come time immemorial, nobody has discontinued it. But efforts are now going on to discontinue it. If you see Supreme Court is working very hard to come up with a common way of understanding law for everybody.
But from examination point of view, I would say it is better to remember these, because we have in this chapter, we have around 10 to 12 maxims only. And that are very well given in the Saransh also, if you see that. Students, you have the link for the Saransh. And if you see that, it will give a professional touch to your answers. We are not saying that we will cut your the ICAI will cut your marks for that, but it gives a special touch. And remembering 10 to 12 maxims will not harm you in any way. And that the way I was telling you, that if you understand the meaning, instead of just mugging it up, it will become very easy for you. Answer, I think we can say, like there is one more, absoluta, senentia, exposure, non-indigent. Even I am remembering that. I am not that good at Latin maxims.
So frankly speaking, I'll tell you, I am a lawyer. I don't remember any of the maxims.
I have to remember because of them, sir.
Yeah, I know. But when I read it, I understand what it is.
Yes.
So that is more important.
So for my students, sir, I will just help them with just one more, which is like, if I say absoluta, what I think is something which is absolute. Absolute in simple English terms means which is clear. Okay, students. So senentia, I can't make out, but it means a sentence or something which is written. And expositor, non-indigent. Non, I know, it means not. And if I say indigent, that you have to remember because it is used in one more Latin maxim. Indigent means that interpretation. So now I can make out something which is absolute or clear statement, and non means no, and interpret. So if I make it a clear sentence does not need an explanation or does not need an interpretation. And now you can make out why we are using it in a literal rule of interpretation. Because in literal rule, we are saying that you have to take the things as
it is.
They are meant to. So this is the way you can do it.
Yeah.
So students, if you have any other query, you can ask us, and and if you want me to explain you anything else, you can ask. Or sir is there.
Very well explained that maxim. It's good.
Anything else, students? So you have anything for them?
Nothing specific. I'll share this presentation. Let me have a look at it once, and then I'll share it on the portal. You will get it. And any questions you have, you can ask us. And I think ICAI is doing a great job. They are giving so much of a support, not only from one lecture, but extra lectures. So it's good.
Okay, sir, I will take this question. Ma'am, other law seems a bit difficult than corporate law. Okay, other law seems to be a bit difficult for two reasons. First of all, Companies Act is one act, even if it was not there during your 10th, 11th and 12th time period, but somehow we were reading its provisions or the gist of it even in our accounts paper. Bonus ke time pe we were reading it, dividends ke time pe we were reading it. So somehow it is in our mind. I'm telling you the mind game. Okay. Now when we are reading Companies Act at your foundation level, you did only a portion of Companies Act. Okay. There was a chapter on Companies Act. But when you are coming to the intermediate level, as such, 3 new acts have been introduced. LLP also you got familiarized in your foundation. But if I say about the Journal Clauses Act or the Interpretation of Statutes and the FEMA, so some of the terms you will be hearing for the first time. So we are not familiar with it. But if you start reading it, you will understand that it was not difficult. You just have to revise it more or make a bit of more effort. Frankly speaking, you can score more marks in it because of the kind of questions that come in your exam. You don't need a very expert knowledge. You need a working knowledge. So in these 2 acts and 1 interpretation, if you see and you try to what they are saying in the acts or in the interpretation in your daily life, like the same thing we used to say you for the Contract Act also, things will become easy me again. नहीं समझ में आ रहा उस लेक्चर को सोते it will be embedded in your mind. और फिर अपनी स्टडी पर. Okay, बेटा? Anything else? Anubhav, I agree, but as of now, we have to deal with it. I think, sir, no more queries and we can wind up the session, sir.
Right, ma'am. Thank you.
Thank you, students, and thank you for being present with us, and have fun and enjoy. And thank you, sir.
Thank you. Thank you, madam. Thank you, everyone. Bye-bye. Look forward to see you.